Already we are live here from Houston, Texas. Every Tuesday we bring in immigration updates. Emily, what do we have today to discuss?
Yeah, today we want to talk about first the government shutdown. It may happen October 1st if Congress can't get its act together and pass something. So how does that impact your immigration status? What types of processes will be impacted on that so people can plan ahead and prepare for that? Also, we want to talk about an $800,000 solution to the age out problem for kids. How can you use EB-5 and the Child Status Protection Act to ensure that your child does not age out and can actually receive a green card with the rest of the family? Common question that we get is, can people who are on a non-immigrant visa like H1, L1, F1, can you trade stocks? Is there a problem with that? So we're going to debunk the myths on that. And lastly, common question that we get is about people who are in the EB-1C category who have a pending adjustment of status and are looking for a change in job after they've filed. Is it possible to change jobs if you're in the EB-1C category? I think a lot of people think that it's not possible. There are certain limits to it, but it can be possible. So we'll discuss that. All right, so first up, government shutdown. What types of cases are impacted? So first off, USCIS generally is not impacted because everything we file with USCIS, we have to pay a filing fee for, and that filing fee is what funds that agency. So USCIS will continue to accept applications and petitions, and they will continue to process them. Same thing with Department of State, who handles all the visas. So if you're outside the country and you're waiting for your visa interview or something like that, you paid a fee, that DS-160 fee, for your visa to be processed. Because you paid that fee, the Department of State can generally continue that process. The biggest impact is with things that go through the Department of Labor, which are going to be LCAs. Those are needed for H-1Bs, for H-1B1s, and E3 visa categories. And then the PERM process and prevailing wage are going to be impacted because all of those with the Department of Labor, there's no filing fee paid. So it has to be funded from the government budget. And if we have no money in the budget, everything stops. So, Raul, what specifically happens to PERM applications? So will they continue to be processed? Can you file it? Where does the process stop?
No, the Department of Labor will close completely. They will not function. They will not approve the LCAs. They will not approve the PERM applications. So that's going to be a major problem, Emily, for the people whose H-1B is expiring and they want to extend it. They're coming near the 6 years of the H-1B and they want to file a H-1B extension. Or even if the PERM is getting if the PERM is not approved, they can't file an I-140 application. They can't extend the H-1B. So that's going to be the major problem right now for the people when the government shuts down. Also, Emily, to be noted that the e-verification, though, of the I-9s cannot be done because they're going to shut down the website of the e-verification. But they are not going to penalize the people if anybody employs the individual before the e-verification has been done. So they will not penalize. That's what they will do. And so people who which companies are on e-verification companies, they can have a manual I-9 form filled and they can employ them, and the Department of Labor will not penalize them. But the e-verification online system will be shut off. With regards to the visa services, though, the consulate visa services, we are not expecting any problem with the visa services there because it's a fee-based, because when people apply for the visiting visa or when they apply for the H1 H4, it's a fee-based. So that should be running smoothly, though. We're not expecting much problem from that, though. CBP, which is when people enter into United States, that's the Customs Border Protection Unit. That should not be. It's an essential function of the United States. So they will run that CBP function, though. So the major problem I see is with the Department of Labor.
All right. So, you know, for H-1B extensions, transfers, E3s, and H-1B1s, Really, the LCA would have had to have been submitted by this past Saturday in order to be certified before October 1st to allow people to file, assuming that the shutdown actually happens. So it may be too late to take any action for H1Bs, H1B1s, and E3s that are going to need to be filed during the shutdown, if there is one. But for labor certification, we can continue to file those up through September 30th. Prevailing wages can still be submitted up through September 30th. So there's still time if someone has a time-sensitive issue with they really need to get their labor filed because of a 7th year extension for their H1 or something like that. But yeah, we're definitely getting down to the wire. Now, in the past, when we've had shutdowns and the LCA has not been available, I do recall USCIS giving kind of a grace period to allow people to file something late if the reason for the late filing was they couldn't get the LCA for the shutdown. I would expect the same thing will happen this time around, but they don't typically announce that in advance. We have to wait until a shutdown actually happens for them to tell us what they're going to do. Same thing with labor certification. If you're waiting to file and can't file because everything's shut down and your advertisements expire, your recruitment matures and you can't file. I think the Labor Department has given us extra time to file in the past when things reopen. So hopefully that will be the same. So the main thing is going to be just longer processing times, I think.
Let's move to the second topic, Emily. You said you have a solution for the age-out kid, but that's going to cost the families $800,000 for the age-out kids. So that means that if somebody is waiting for the line in EB2 and EB3, and it's going to take a long time for them to get the green card, they can pay this $800,000 to the USCIS approved EB5, and they can invest the money, and there is a solution for it. Can you explain more about it, Emily? How the EB5 is going to work? How that may save this individual child aging out? Because if they are going to wait for EB1, EB2, EB3, the child will be aged out. In other words, the child have to do their own application of F1 and then going in a H1 and then the green card. Who knows how long it's going to take for the kid to get the green card. But the EB5 might be a solution that you came up. Can you explain more about it, Emily?
Yeah, so the Child Status Protection Act is helpful in that it allows you to subtract the amount of time a petition was pending from the child's age to see if it makes the child under 21 for CSPA purposes. Now, for employment-based EB1, EB2, EB3, we're talking about how long has the I-140 been pending. That's the only amount of time you can subtract from their age, which generally I-140s get processed in 6 to 8 months. If you did premium processing, it's 2 weeks. So we only have a little bit of time we can subtract from the age. The difference with EB5 is the petition that's used to file for EB5, the I-526. A couple of years ago, USCIS changed how they process it, and they only process those where the priority date is current or about to be current. So you file your I-526, and let's say your priority date doesn't become current for 10 years. Your I-526 is going to be pending for 10 years. That means you can subtract 10 years from your child's age. And if that makes them under 21, maybe they're 31 now, but you subtract those 10 years, it makes them under 21. They could still adjust status with you, assuming they've maintained their non-immigrant status by switching to F1 and eventually H1 or O1 or those sorts of things. So it's kind of another potential option. Obviously, it's very expensive, but that's also how they process family-based I-130 petitions. They don't approve those quickly if the priority date is not going to be current for 10 or 15 years in the sibling category, for example. They just sit on it. And all that time gets to be subtracted from the kids' ages. Why don't we do the same thing? I mean, they do that for EB5 now. And so that could be a way for those that have the financial means to ensure that their kid's age is going to be locked in. It doesn't necessarily lock their age, but it makes more time that you can subtract from their age by the time the date does become current to maybe get them under 21. So that's one option. I'm also looking into, you know, if USCIS is doing that for I-526s and they're doing it for I-130s, maybe we should ask them to do something similar for I-140s. And so I posted on my blog, I know I haven't posted on there a long, but if you go to immigrationgirl.com, we'll write up about kind of this brainstorm idea that I happen to have on my commute to the office this morning, to see if maybe that's something we can propose to USCIS, because obviously we've tried proposing making the filing dates current. That would have also helped the age out kids, and that didn't happen. Obviously Congress isn't doing anything for age out kids at the moment. Maybe this is another option we can get them to consider while we work on more long-term fixes.
Emily, with regards to the I-526, we can file the 485. The dates are current right now, is it right? Previously, we had to wait until the I-526 is approved and then file the 485 application. So practically, since the dates, most of the dates are current for EB-5, we can file the I-526 and 485 and immediately save the person, because then the 526 will take a long time. Most probably, they'll be saved either way, though. So that's definitely.
Yeah, I think we're only current for the infrastructure and the rural right now. I don't think if it's just a regular old EB-5 investment, it's not current.
Yeah, if it's not current, also they're saved. If it's current, also they're saved. Either way, they should be in a very good, comfortable position, especially if somebody is wanting to make sure that the children come under the EB, the child is saved, though. Then they have to come up with the $800,000 investment. Now, I just want to let you know that it has to be $800,000 investment. You cannot take from the business that loan, and this is only for the things where it's approved by the USCIS. And if you want to put your own investment, then it's a different amount that is there. Green card, a lot of people are under the assumption that they put the $800,000 green card, they're going to get the green card immediately. No, that's not true. It takes almost 10 years to get a permanent green card. You may get a temporary green card in about 5 years, but to get a permanent green card, it will take about 10 years. But this will actually allow the people to get the employment authorization by filing an EB-5 application. This will allow the child to be saved so that along with the parents, the child will get the green card. So keep that into factor when you want to invest this $800,000. Can we go to the next topic, Emily?
Yes, trading stocks. So if you're an H1B holder or H4 holder, maybe you're an H4 holder and you don't even have employment authorization. Can you trade stocks and make money off from it?
Absolutely.
Is that unauthorized work?
Absolutely, you can. What about, Emily, for example, if there is an H4 and not an EAD, doesn't have the work authorization at all, can they still trade stocks and make money?
Yeah, absolutely. No problem with that at all. You know, the H4, when you don't have the EAD, you're not allowed to work. That doesn't mean you're working for the company by buying their stock and selling their stock and making a profit off of that. That's not considered employment. So that you can do that. So if you want to trade some stocks and make some money off from that, no problem at all.
There are things like options. There are things like different kind of things where they do the stock market. Anything is fine, guys. Now, we are not financial advisors. We're only advising that immigration-wise, you are fine in trading the stocks, making the money. Absolutely not a problem at all. Anything else, Emily, before we go to the next topic?
No, we can go to the next topic. So EB1C.
EB1C, this comes very commonly asked question to me, Emily, when we do the daily conference call. We're getting like 3-4 questions every day on this EB1C. Now, especially with the EB1C is backlogged now in the 485 application, where the final action date is 2017. Some of these people have filed 485 application in 2021 and 22. It's not been adjudicated right now. Now, can they change the job, Emily? I know that for EB2 and EB3, everybody knows that they can change the job after the 485 has been pending for 180 days. Can they change the jobs in EB1C also?
Yes, AC21 does apply to EB1, EB2, and EB3. So as long as the new job that you're being offered is in that managerial or executive capacity, you can move your 485 to the new job if it's been pending for 180 days. But in that situation, assuming you were on L1, you do need to have the EAD first to be able to work for that new employer. Because in this case, you can't transfer an L1 to another company because you didn't work for the new company abroad for 1 year. So you're just moving your 485, keeping that alive with respect to the new job offer, but you also have to have employment authorization to work for that new company, which is typically going to be your EAD. But yeah, I just had a consultation on the same issue yesterday. So it comes up quite a bit. I think there's a lot of misinformation out there. A lot of people think that because it's EB1C and because you had to work for the company abroad, that you cannot take advantage of AC-21, but that is not true.
Do they have to work in the foreign country? For example, let's say, for example, the person has worked with Cognizant India, and then now they have transferred to Cognizant United States, and they got their EB1C 485 filed. Let's say they want to transfer to Microsoft, or let's say they want to transfer to Coca-Cola company. They haven't worked outside the country for 1 year, which is a requirement, absolute requirement for EB1C, that they must work for the foreign corporation for 1 year, the same sister or affiliate corporation. But do they need to do it for when they want to move to Coca-Cola company? Does
Nope.
they have to work for it?
Nope. Just the U.S. company needs to submit the supplement J if there's a request for evidence or if you get called in for an interview. No requirement to work for the company abroad.
Emily, some questions are coming though. I want more discussion on it. Maybe I'm right, maybe I'm wrong. It's been very long time that there was been a shut off, and I don't think so. You've been practicing immigration law since the time there was shut off.
Yes, I have.
Yeah. Okay. Well, that was
There's
not a
definitely
major
been a
shut off.
shutdown in the last 20 years.
Okay. Oh, well, previous to that, there was shut off was for a long period of time. When you came in, it was a short period of time. But the question that came out in there was that, hey, 485J supplement doesn't require filing fees. What about that? And that creates another doubt to me is that, what about the EAD and advanced parole? That doesn't require a filing fees. Can they be processed? Can they be filed?
Yes, they can still be filed, and yes, they will still be processed, because it's not that, you would think about it, I'm paying a fee for whatever my application is, and the money I pay goes towards my application process. That's not really true. You're paying a fee, but that fee goes into a general pool that runs everything USCIS does. So even if you're not paying a fee for your EAD AP renewal or for your supplement J, you've paid fees before, everyone else has paid fees. They all go into one big pool, and that is what continues to operate the entire agency. But that's a good question.
Good question. Question that came in on the YouTube, whether a person on H1B can partner an LLC. Now, there is a difference here, though. Can you own the LLC, or can you manage the LLC, though? As far as the ownership is concerned, absolutely, you can own the shares of the LLC, no problem with it. But if you want to work as a managing partner, or if you want to work for that company, you are not allowed to work for that company. But as a shareholder, you can be the shareholder of LLC or any incorporation on an H1B. Absolutely not a problem. Question from Ali Haider. I-140 filed 2 months back, normal processing, upgrading it to premium processing. Would that lead to an RFE? No. The stats does not justify that just because you file a premium processing, you are going to get an RFE. That is not true at all. We do file very frequently. The only thing is that it expedites that. Let's say, for example, you are supposed to receive an RFE 6 months down the line, you're going to receive it right now. So we do not anticipate that more RFEs are coming just because you file a premium processing.
Question from Emily. She says, with the exemption of the biometrics fee for I-539s, does this mean premium processing for change of status to F1 clock will start the day the application is filed? Yeah, so we didn't talk about it, but that's also big news. USCIS came out yesterday and said, you know what, we're done with requiring biometrics for any I-539. So if you remember back before Trump, we never had to pay biometrics for an I-539. Then Trump came in and said, everybody who's filing an I-539 has to pay biometrics and go get your fingerprinting done. Even little kids. Made no sense. So of course, we eventually filed a class action lawsuit that got it suspended, but only for H, L, and E dependents. That suspension was supposed to end September 30th, right around the corner. And instead of extending the suspension or bringing back biometrics for those people, they eliminated the whole thing. So nobody has to pay biometrics anymore. No one has to be fingerprinted for anything filed on an I-539. So about F1s, when they came out with premium processing for the F1, they said, we're going to adjudicate it in 30 days. Sounds great, right? Until they come in the fine print and say the 30-day clock doesn't start until we've done your biometrics. And then they were taking 3 to 6 weeks for biometrics. Now you've got another 30 days to wait on top of that. So although there's not been any announcement, if they're eliminating the biometrics for F1 change of status, that means they should be counting the 30 days from the day the F1 is filed. Again, we don't have any official announcement on that, but I don't see how they could possibly delay it beyond 30 days now that we've taken off the biometrics.
Question from Shinde. Mr. Shinde, he has filed adjustment of status. He has an EAD. His wife is an H4. Now he's unable to use the EAD. The reason is that he didn't file for his wife 485 application. And if he uses the EAD, he's going to lose the H1B, and thus by his wife will become out of status. Is there a solution? Can we file when the priority date is not current? No, you cannot file when the priority date is not current. You may think of some alternative thing. For example, instead of having your wife on H4, you can move on to F1 visa. That may be a good option, where you can move on to the, if you plan to move on to the EAD, you can move on to F1 visa. That may be a good option for you. And there are ways where you can resurrect your H1B and come back later on, though, by filing a H1B later on in case you need that at a later date.
Kunal says, my AP was filed in February 2023 and current processing time says 18 months. Will I get denied if I travel to Mexico while my I-131 application is pending? So assuming that this is your initial advance parole, yes, it will be denied when you travel while it's pending. If this is a renewal of your advance parole and your original advance parole has not yet expired, and you travel and come back on your original advance parole before it expires, the pending one does not get denied in that situation.
Sri Lanka has this question. I'm filing an I-485 for myself and my son who will be aging out in 2 years. Only filing date is current now. Will the CSPA lock the age? Yes, I'm assuming that the I-140 is approved. In that case, you have to have 4 requirements to meet right now. The filing dates have to be current, and the USCIS is allowing those filing dates. The child is under 21. I-140 must be approved. You must have filed the 485. Since if you're going to file in October, the filing dates are current. I'm assuming your I-140 is already approved. Then you're meeting all the requirement. There is a recent change in the USCIS interpretation. Previously, it was only the final action date. Right now, it's the filing dates. Sam is asking this question that some of the YouTubers are telling that that I-140 has to be restarted if you change the company. Now, there are 2 different scenarios this question might come up, Sam. Assuming that you filed the 485 application, assuming it's been more than 6 months that the 485 application has been filed, and if you want to change the company from company A to company B, and your job is in the similar classification, you absolutely do not have to file the I-140 application with the new company. It's only the I-485J supplement. Now, if you have a company A I-140 approval, you didn't file the 485 application, you're moving to company B, and you expect to get the green card through company B without filing the 485 application, then you have to file a labor and I-140 with company B, because company B cannot file the 485 application unless there is an I-140 approval for them. So if there is a 485 and more than 6 months, you don't need it. If there is no 485, you may need an I-140 approval.
SJ says he was originally on OPT, got his H1B and had transferred, and then the company mistakenly ran the payroll for more than a year without taking out the deductions for Social Security and Medicare. They realized it when the CPA pointed it out and they fixed it, but he wants to know if it's going to be a problem for stamping or a problem in the future. So people that are on OPT if they're in F1 status, typically for less than 5 years, they are considered non-residents for tax purposes, and they do not have to do all of the same withholdings that other people in H1B status have to do. So when you're converting from F1 to H1, when your H1 kicks in, you need to make sure that your payroll is being updated to have those additional deductions taken out. And actually, attorney Stephen Brown and I are doing a webinar on Thursday for HR people in the onboarding process on what to do for H1B holders when you're onboarding. And that is one of our topics that we're going to be covering. But to answer your question, it's a tax problem. It is not a status problem. So it's not going to cause any issues when you go for stamping or anything for the future in your green card, but both you and your company need to work with the CPA to see if you need to file amended tax returns, see if you need to change your deductions and that sort of thing going forward. But it's not going to be a status problem or any immigration problem.
Rangarao has this question. He's an adjustment of status EAD. Can he work for 2 companies on adjustment of status EAD? Absolutely, he can work for 2 companies. I've had some people working for 5 companies, especially in the medical profession and certain other professions. I've seen them working for many different companies, no problem for it. Fazim Khan has this question that Fahim Kazani has this question. That's a good name. Fahim is my ex-boss name who first taught me what an immigration law is. That's a good name. And Fahim is asking that question from YouTube that if he is on, he just got the H1B approved right now, when can he start the green card process? Is there a waiting period? Absolutely, there is no waiting period. In fact, you don't even need to have a H1B at all for you to start the green card process, especially for the rest of the world people where mostly the prior date is current. Even right now, practically it is current. Though we tell people to file, you don't need to go through the H1B. Directly from OPT and STEM extension, you can file the POM application and get the I-140 and avoid the H1B completely.
Sahil wants to know if a prevailing wage determination, the ETA 9141, can be withdrawn so that a new one can be submitted. And if yes, does it cause any issues during the perm and I-140 stage? Yes, absolutely. There's no problem at all with withdrawing a prevailing wage. If you realize that there was incorrect information or maybe something about the job changed, that necessitates a new prevailing wage, you can withdraw the current one, submit a new one. Once you withdraw it, it's as if the first one never existed, so it has zero impact on any future filings. You don't use it for anything going forward.
Question from Mohan Singh. He was an H1B, completed 6 years, and then he moved to F1, and it's been 1 year that he's been F1. Can he move back to H1B because he completed 1 year of F1? No. For you to move back to H1B, since you completed the 6 years of H1B, you need to have an I-140 approval, or the labor certification must have been pending for more than 1 year. The 1 year should be outside the country you're speaking about. If you're outside the country for 1 year, then you don't need an I-140, but you still need to go through the lottery system. So if you are here right now, I want you to file the form, get a form and I-140 approved. That would be the best solution for you.
Ali says the I-140 was filed 2 months ago in normal processing and wanting to know about upgrading to premium processing. Does it lead to RFEs or increase the chances of getting an RFE? So my experience is generally no. I don't see a difference in RFEs, the issuance of RFEs for the most part between premium or regular for I-140s or I-129s. That being said, from time to time, when we have a premium processing case, sometimes we get really silly RFEs that would suggest that maybe they're just trying to buy extra time because they can't process the case fast enough. So yes, that does happen, but I would say it's a very small percentage of the time. Overall, I enjoy premium processing and do not have many issues with getting those kind of weird RFPs, but they do happen from time to time.
Johnny is asking the question that he has an EAD, GCEAD. Can he work for one company on H1B? And on the side, he wants to work for his wife's company on GCEAD. On the H1B, he will work for one company? Absolutely. We don't see any problem whatsoever at all. That you're working for one company, let's say Coca-Cola, and then you're working on GCEAD for your wife's company. Nothing wrong with it. Santosh has this question that if a person gets laid off on H1B, can the spouse continue working on the H4 EAD? Up to 60 days, she can work on H4 EAD, but after 60 days, she has to stop working because there's a grace period of 60 days that allows them to stay in the country. But after 60 days, she has to stop working unless you get another H1B and you start working.
Yahoo Me says the AOS was filed in October 2020 and got the EAD and AP, moving states but staying with the same company. In addition to the AR11 form, what do I need to do to update my address with USCIS? Do I need to send a letter? Is there any issue with the EAD and AP renewal after I move? So typically just the AR11 needs to be done. That being said, when you fill out the AR11, if you do it in the online version, it will ask you, do you have a pending application with USCIS? You want to answer yes and provide your I-485 details so that your address change can be applied both to your profile in general, but also to the pending 485 so your green card gets sent to the right address. When you're doing your EAD AP renewal, because you've already got your EAD AP, you don't have to make any updates. You don't have to give them that receipt number. But when you file the next one, you just file it with your new address. So there's no extra steps that you need to do besides the AR11. If you want more details on that, I do have an article on rnlawgroup.com about the AR11 and the different options for how to submit it and how to make sure that they are updating your pending case. So you can just search for AR11, rnlawgroup.com, and find that article.
Vipin Jain has this question from Facebook that a person with H4 without EAD, can they trade stocks? How can they do that? Well, they can. Absolutely not a problem. Not a problem at all. They can.
Mark says, my priority date is not current. I work for the same company that filed my I-140 and AOS, and I still received an RFE asking for the supplement J. Of course, we're going to respond to it, but it makes no sense. Thoughts? Yeah, USCIS wastes so many resources and time. It's ridiculous. We get RFEs for medical exams when the date's not current, RFEs for supplement Js. We even have people called in for 2 interviews when the date is not current. And for the second interview, the officer said, I have no idea why we called you in for an interview. Go home. So yeah, they waste so many resources on these, just wasting time for no reason. I don't know.
Abhiraj Bhosle is asking the question, and this question comes in very frequently. When the date is not current, I got an RFE for medical. Should I respond to it or should I not respond to it? Respond to it. Your 485 will be denied if you don't respond to it. You better respond to it.
Suma says, on H1B, have a priority date in 2016, and my spouse has the H4 EAD and wants to know, while my new perm and labor are in process with the new employer, will the spouse be able to renew the H4 EAD based on the I-140 of the old employer, or does she have to wait for the new labor and I-140 to be approved? So since 2017, the regulation came out that clarified that as long as your old employer's I-140 was not withdrawn within 180 days of approval, you can keep using that old employer's I-140 to extend your H1B and to extend your spouse's H4 and H4 EAD, even if your new employer doesn't have a new I-140 in place yet. So yes, she can continue to use that, assuming it was not withdrawn within 180 days of approval.
I have an interesting question. That this is from Priscilla Franco. Assuming that she is from India, she has this question. Well, give me 1 second. That's not the person that asked the question. The person who asked the question, I couldn't name that person right now. The question was that, oh, this is Venkata Padmakumar, that if the priority date is going to be 2024, I'm assuming that it's going to be in either EB2 or EB3, will I get the green card before I retire? Highly unlikely you will not get the green card though. Right now, the green card process is only for you to get the H4 EAD for your spouse, to get the H1B beyond 6 years, and if some miracle happens, to get the green card. But as such, if you're going to apply in 2024, there are so many people before you, unless you plan to retire at the age of 120 years.
Subramani says, I transferred the underlying basis from EB2 to EB3, and now it's current in EB3. Is there a problem to relink EB2 to EB3? So maybe you went the other way around. You went from EB3 to EB2, and now you want to go back to EB3? I'm assuming that. So yeah, you can go back and forth between EB2 and EB3 multiple times, as long, whichever date happens to be current. You can't do it through a service request though. Those officers, when you call customer service, won't be able to help you with that. So you have to go through the transfer of underlying basis process that was announced in early 2021, I think, where you have to submit another supplement J, tying it to whichever I-140 you want to use going forward, whichever one is current. And yes, you may have to do that multiple times as we continue to see EB2 and EB3 flip-flop.
Question came from Gaurav. Gaurav's daughter is on H4. Is there any way that we can get an EAD on H4 and can she start working? Unfortunately, no. The children are not eligible for H4 EAD. It's only the spouse who's eligible for H4 EAD. The only route that I can think about is to apply F1 visa. That's one route that you can think about to get the work permit.
Sundeep just got his I-140 approved, but he already filed for his H1B extension in the regular processing before the I-140 is approved. Now he wants to know if he can convert his H1B to premium processing and file the H4 EAD for his spouse, and what are the chances of getting them approved simultaneously? I would say 0.01%, because when you do the premium processing, that is only for the H1B, and they only premium process the H4 EAD if it was filed concurrently with the H1B. So if you're just now filing the H4 EAD, number one, it goes to a different address. You can't even include it with your premium package, but it's going to have a later receipt date. So they will not consider that to be a concurrent filing, and you won't get the benefit of premium on the H4 EAD, unfortunately.
Karunesh is asking this question. What's the best time to file an EB1A application? Are you thinking because the priority date is not current? If that's the case, so file it right now, though. Get the EB1A approved right now. In fact, if I have to say that in the past 30 years, what is the best time to file the EB1A? Right now. I mean, the approval ratings are very high right now. The administration is quite different than compared to the previous administration. And the other thing, what people are hesitant in the EB1A application is that just in case, if your EB1A gets denied in the first instance, though, can you reapply the EB1A again at a later date? Yes, mostly because you may accumulate some more information, some more publications, some more eligibilities for EB1A, and then you can build up the case and file the EB1A later on. So let's say, for example, you file a EB1A right now, you get a denial. You can see the reasons for the denial. You're not eligible because of this, because of this, because of this. You can actually build up upon that thing and make those things. Let's say, for example, either you become a member of internationally acclaimed organizations or certain things. You can become a member of those organizations and then go and refile the application. Then your chances of approval will be very high. So you can test the ground and see what is the causal failure and improve upon it.
Abhi says, if I lose the job on H1B and I have a home loan, is there a way to stay in the US based on these financial reasons? No, so there is no visa category that allows you to enter or be in the U.S. Based on financial hardship, for example. That being said, if you have an approved I-140, there is an I-140 compelling circumstances EAD, and the job loss combined with financial issues can be a compelling circumstance that qualifies you to get the I-140 EAD, and that allows you to stay in the country. Ryan Wilk is one of the partners with our office. He handles those I-140 compelling circumstances EADs. So if you want to reach out to him, he can help you and guide you on that process.
Quality Canada, and he got the EB1C approved. What are the chances for him to get the green card by 2028? I think so, very highly likely by 2028. That's my estimate. I may be wrong, but yeah, that's my estimate that you will be getting the green card before 2028.
MK says, is the third lottery going to happen? It's too soon to tell. We don't have any information from USCIS yet, and the filing window for the second lottery doesn't end until next month, at the end of the month. So we'll only find out after October 31st. That being said, I would not be surprised if there is a third lottery based on the number of duplicates in the registration process and how many duplicates got selected a second time around, or for how many people who already had an H-1B approval got selected with another company and won't be filing. So I would not be surprised if there is a third lottery.
LPM is asking the question that if he got the green card, he wants to travel for 7 months to outside the country and come back. Well, there is a good chance that you will not have any problem if you're traveling only first time for 7 months period and coming back. But there are some negative consequences you may face if you are keeping it 7 months. If you keep it at less than 180 days, then you may not be questioned at the time when you go for the citizenship. If you keep it more than 180 days, you may be questioned about that why you left for more than 6 months though. So under your conditions, I mean, if you can possibly make one more trip and come back into the United States and go and avoid us, it's worth probably doing it.
Arvind says, is it possible for an H-1B transfer during a shutdown? Possibly, but unlikely. So the only way that would work is if your H-1 transfer process is already underway, meaning that the LCA was already submitted before last Saturday. In that situation, the LCA could still be certified by September 30th, and then the transfer can be filed anytime during the shutdown. But if no LCA has been submitted yet, it will not be possible to do a transfer during the shutdown.
Question with regards to Sendil, not Sendil. This gentleman has filed an EB1A, got approved, and he has a J visa and he wants to travel outside the country and come back. No, don't do that. Because J visa requires that you must have an intention to temporarily stay in the United States. When you're entering into the United States, the CBP officer will ask you the question, what's the purpose of the visit? That's automatically everybody, they have to ask a question. And when you say that you want to enter for completing the temporary nature of the J1 that you are in, that violates the problem. Now, this is only for certain non-immigrant visa people. If you would have been on a H1, if you would have been an L1, and if the EB1 has been approved, it's not a problem for you to travel. But when it is a J1, though, it is definitely a problem. I recommend you do not travel.
Sonia said, why are the advanced parole taking so long to get approved for AOS applicants? I still have a valid AP for another month and applied for my renewal as well. Can I travel during this period for a week before the current AP gets expired? So yeah, these AP processing times are ridiculous. USCIS continues to blame COVID for it. And then when they randomly started separating the EAD from the AP so that they could hurry up and try to fix the EAD processing time so people could work. But then they just let the AP go and taking forever. So yeah, their processing times are terrible. We have been filing lawsuits for these delays. So you might want to consider that. But in your case, when the current AP has not yet expired and you have the renewal pending, you could travel and come back on the current AP before it expires, and your renewal application will not be negatively impacted. But if you travel and try to come back after your current AP expires, that's not allowed.
Can an EAD be filed while the H4 is pending? Absolutely, you can. You can file with a receipt notice of the H4 if you're eligible for the EAD. No problem with it.
Raju says, my perm is in the queue. Will it have any impact from the government shutdown? So assuming you mean that your perm is already filed and pending, yes, unfortunately, it will be impacted. The Department of Labor will not be processing any perms during the shutdown, so your case will not be touched, and it's going to likely delay the approval of perms after the government shutdown is over, because they're going to be even further behind.
EB1 concurrently filing. Dependents get GC same time as primary applicant? Yeah. Sendil, yes. If you file both people's 485 application, very high percentage that both of the people will get the green card at the same time. Sambhunath Manjumda has this question. H1 H4H4AD is filed in premium. H1 and H4 is approved, but EAD is still saying case received. Is it normal? Just wait for one more week though. We see that normally, even though the EAD is approved, it doesn't show it on the record though. Just wait for one more week, then you will get a proper thing. Now, there are chances that sometimes they don't approve though. If they do so, since it's been filed in premium processing, you can request the premium processing units, hey buddy, you're supposed to approve my EAD at the same time. What happened? And they will approve that, they will adjudicate the EAD though. But normally 95% of the time though, what I see is that if you wait for 1 week, it shows that it's been approved.
AS says, do we need to file an AR11 form if we're an H1B holder and move to a new address? Yes, so pretty much anyone who's not a green card holder or a citizen needs to file an AR11 whenever they move. That is a requirement for anyone who's present in the US.
Shahul Hamid has this question. He got the green card and from H1B. What are the steps then he need to do? Does he need to apply a new SSN? No, definitely not a new SSN. Some people in the SSN, it says that only with immigration authorization, that wording is there. I don't know the exact wording, I forgot it right now. You can go to the Social Security office and request to change it. And believe me, I got my green card a long time ago. My still Social Security numbers, I did not update my Social Security card with the new information. You can, it's up to you. I mean, there's nothing wrong. If you don't, nobody's going to ask you, nobody's going to create any problem for you. But no new Social Security number will be given after you get the green card. It's the same Social Security number.
HF says, what is my current immigration status? My H1 was approved in June 2023. I traveled and re-entered the US using my AP in July 2023. This is a question on the EAD renewal I-765 application form. So your status is whatever you want it to be, basically. Even though you entered on AP, if you're still working for the company that got you that H-1B approval under the terms and conditions of the H-1B, you can consider yourself to still be in H-1B status and able to extend that H-1B. If you want to use the EAD instead, you can consider yourself to be in adjustment of status and utilize just the EAD going forward. So either one is fine for the I-765 application.
My wife has traveled to India before getting an EAD and AP and has an H4 visa. The question is that, will I get GC in the meantime? Just because your wife has traveled outside the country, they're not going to stop you from getting a green card. If you're eligible for it, your priority date is current and the officer is working on it, they will give you the green card though.
Sendo says, my lawyer's renewing my H1 and they're planning to apply for the H4 EAD for my spouse, even though she has an AOS EAD. Is it good to apply for it? I heard about this new rule that says they will give a 5-year EAD. Will she get a 5-year H4 EAD? So yeah, USCIS, or actually Department of Homeland Security, last week had announced in the fine print that they intend to start issuing EADs for 5 years instead of the typical 1 year or 2 year, so that they can reduce their workload and actually finally get caught up on some of their processing time. So that's definitely a good sign, but it does not apply to H4 EADs. The longest an H4 EAD can be extended is the date that the H1B expires. So they'll never get a 5-year H4 EAD.
Sanjay has this question, two questions actually from Facebook. I-140 has been filed in June 2023. How long does it take for the I-140 to approve in the normal processing? Anywhere between 1 month to about 7-8 months is the processing time for the I-140. There's a different question though. Can EB1 filings for the management, which I think so is speaking about EB1C, can we file from different consultancy organizations? Now, for you to get an EB1C approved from a company, though, you must have worked for the foreign affiliate of that company for at least 1 year. So let's say, for example, you're working for Coca-Cola India, and if you want to get an EB1C approved, you can only get from Coca-Cola United States. You cannot get it from Pepsi. You cannot get it from ABC. You cannot get it from Deloitte, because you did not work for Deloitte or ABC outside the country. Only the company that you worked, like Coca-Cola India, then in this case, Coca-Cola USA can file a EB1C application.
And then says the prevailing wage determination was filed in December 2022, and still no update from DOL. So a prevailing wage was refiled in July 2023. Do I have any option to expedite? Unfortunately, no. The Department of Labor does not expedite any cases for any reason. They don't have the same expedite criteria that USCIS does. We did look into the possibility of filing lawsuits based on delays in processing from the Department of Labor. We were kind of looking at two different options, filing a lawsuit for perm delays and also filing a lawsuit for prevailing wage delays. We kind of decided against the prevailing wage delay lawsuit, mainly because it's got to be the company that files it based on our research. A prevailing wage determination does not belong to you as the employee. Your name is nowhere on that application. It belongs to the company. So if we're going to try to expedite through a lawsuit for delay litigation, it has to be the company that files it, and a lot of companies are not willing to do that. We did end up filing a lawsuit for perm delays, and that is still ongoing. So hopefully we'll have some good news to report. We filed a motion for summary judgment recently with a lot of data from an expert statistician that we had hired. So hopefully we'll see some positive outcome from that.
My priority date is June 2018. Is it okay to switch new company now? I can't tell you yes or no to this question because the dates move very randomly. But I would tell you that if it is 2018, based on the current circumstances right now, I am going to move to a different company if I get a better opportunity, because I'm not expecting the priority date to become current soon under the current circumstances.
VTV says, can we process the H1B for the second lottery round during a shutdown? So if an LCA has not been filed yet, no. And the government shuts down, no, you won't get your LCA approved in time to be able to file. But if you already have the LCA and then the government shuts down, yes, the H1B petition can still be filed up till October 31st.
Venkat has this question from, Venkata from YouTube has this question that his priority date is 2014. And do you see that the green card is going to come in the next 6 months? Should I move back to Canada to take advantage of the green card in Canada? That's a tough call. I'm assuming that you filed the 485 application, though. I would not move to Canada. It's too cold there. The employment opportunities are not that good. Since you filed the 485 application, if I were you, I would not. Now, I cannot answer these things. These are not legal questions. These are more personal questions. So, I mean, both are legal. You staying here in the United States, going to Canada, both are legal. So I'm just telling, if I were you, what would I do though? Would I go to Canada? No, I would not. Even though I know that the 485 application is not going to be approved in the next 6 months, I am not going to move, but it's your call.
All right, well, I think we are out of time for today. Don't forget to subscribe to our YouTube channel if you are new here, haven't done that yet. That way you'll be notified whenever we do go live or post new videos. We do post a lot of shorter videos during the week in addition to this weekly live. And you can always consult with Raul or I or any of our attorneys by going to rnlawgroup.com. There's a button there that you can click for consultation. You can see all of our schedules online and see what areas different attorneys have and decide which appointment you would like to book. It's very convenient. So you can do that at rnlawgroup.com.
Thank you very much.